Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 96. We've got the usual three cases. The first, it deals with enforcement of restrictive covenants, where the court is looking at matters after a trial rather than at the usual interim stage. Then there's a case on whether a working practice which had never been explicitly enforced could be a provision, criterion or practice for an indirect discrimination claim. And finally there's a relatively rare case on the working time regulations. As usual, don't forget you can access the podcast via iTunes or on the Mayor Brown internet or YouTube, and the Twitter feed is Nicholas Robertson at Nicholas R-O-B-E-R and then the number 1 and the number 1, Nicholas Robert 11. And that's also where we post out links to all the cases discussed. So first case, Pickwell and Nichols and ProCam CP Limited. And this is the case dealing with the enforcement of restrictive covenants following a trial. I don't think I'll claim the case decides any brand new points, but I wanted to go through the case because I think it deals with a number of interesting issues which can come up from time to time. The two individuals, Pickwell and Nichols, started working for ProCam, as trainee agronomists. And the letter of appointment for each of them was relatively informal and was sent out to them ahead of time. In each case, sometime after they'd started work, but before they'd qualified as agronomists, they were given a contract of employment, a more extensive document. It contained restrictive covenants and a 6-month notice period, instead of the 1-week notice period in the informal letter. They signed the contract, sent it back to the company. In 2015, a rival enterprise hired them, and they gave 6 months' notice. When that expired, they issued proceedings in the High Court for a declaration that the restrictive covenants did not apply to them. Well, the restrictive covenants in question lasted for 6 months following the termination of employment, and there was a clause prohibiting dealing with relevant customers or soliciting relevant customers. The clause was in fairly standard terms. The covenants focused on the previous 12 months and on customers who were people who had, as a result of the dealings of the individual concerned, bought goods or services from ProCam. The employees who were seeking a declaration that the covenants were invalid put forward 3 separate arguments. First, they pointed out the covenants were contained in a contract that was entered into after they'd already started employment. So they said that there was no consideration for the increased burden of the restrictive covenants. Secondly, they denied the employer had a legitimate interest that justified protection. And thirdly, they said the covenants were simply too wide. A lot of the decision is taken up with the issue of consideration. Claimants argued that if there was no consideration given for these extra terms, then, though they'd signed the contract, in the absence of consideration being given to them above and beyond what they were already enjoying, then the covenants would not be binding on them. The judge went through a number of the cases dealing with the issue of consideration in an employment context, where it's not unusual to find that terms of employment mutate, benefits may be given or indeed taken away during the lifetime. The judge looked at the case of Selectron and Roper and asked whether the employee's conduct in continuing to work in this particular case after the new contract had been sent to each of them and signed by them, whether that conduct could only be explained as them having accepted the new terms imposed by the employer. The claimant argued that merely continuing to work and be provided with work was not adequate consideration where they were already under that letter. There needed to be some added real monetary or other benefit. The employer in turn argued that the individuals had actually signed the contract in question. Both the individuals accepted in cross-examination they read the document before signing it and that they knew of the existence of the restrictions. And crucially, both claimants also accepted that if they had refused to sign that new contract, then they would have been given less access to the company's customers, which was very relevant if they were going to develop a following of their own once they qualified. They also accepted they could potentially have risked dismissal. Counsel's employer also pointed out that it was the new contract which gave the individuals the right to receive and obliged them to give 6 months' notice. Both of them, in fact, had given 6 months' notice to the employer when leaving. The company claimed that there had been adequate consideration on the basis that if the individuals had refused to sign that new contract, they would almost certainly have been dismissed. Court's view was that although it was never actually expressly suggested to the two trainees that they would be dismissed if they didn't sign, the employer's willingness to continue to employ them and provide them with valuable status and training to enable them to progress in their careers was sufficient additional consideration. Pausing there, this isn't a particularly easy point, I don't think. The company were already providing training and status in accordance with the informal letter that had been exchanged with each individual. A judge, I think, sidestepped that problem by finding that individuals would probably have been dismissed, and therefore the forbearance from dismissal amounted to valuable consideration. The individuals also challenged whether or not there was a protectable interest that was capable of being governed by a restrictive covenant. Unsurprisingly, they pointed out that they were only trainees at the time, without any experience or customer contact. However, again, the judge dismissed this argument, saying that at the time the contracts were entered into, it was contemplated that each individual would continue, the contract, I should say, would continue to apply once each individual had qualified and stayed on at the company. The intention was they would qualify and stay on, and there was effectively one contract to rule them all, to mangle that Lord of the Rings quote. Each individual could be allowed to deal with their own customers from the point at which their manager judged them at a level of performance sufficient to allow them to act with less supervision. It would be unnecessary, in that sense, to require a new formal contract to come out from HR before they could be allowed to go off and fly solo, as it were. The individuals also tried to argue that the covenants were too wide, and they pointed out that as very junior trainees, they'd had the same covenants as fully qualified and experienced agronomists in the company. They were obviously standard terms. As trainees, they would never have developed the same depth of relationship as a fully qualified and experienced agronomist. And because they were the weaker party and effectively had no choice but to enter the contracts, the covenants were not even properly negotiated in any sense, they said. But this also failed to impress the judge. He accepted the employer's evidence that the 6-month notice period and the 6-month post-termination restrictions were designed to cover one agricultural year, irrespective of when the individual actually left. Otherwise, a well-timed departure could be very damaging at some times of the year, less damaging at other times of the year. In particular, the spring season, which is between February and June in any year, is absolutely critical for the well-being of the business. And the judge also accepted that a replacement agronomist would take time to build up confidence with the farmers, and it would of course also take time to hire competent and experienced agronomists, all of which went to the fact that a 6-month notice period and a 6-month covenant was fair and reasonable. As I say, this line of attack on restrictive covenants is not an unusual one. The comments on whether the employer had provided valuable consideration are quite interesting, quite helpful. If contracts are sent to an individual after he or she has actually started work, there is always going to be a danger. The employee asserts there's been no adequate additional consideration if they ever want to walk away from the contract. Much, of course, will depend on the terms of that new contract and whether there are any additional benefits above and beyond those referred to in the individual appointment letter. Almost certainly, however, the better view is that the contract should be sent out to the individuals before individuals start, rather than after they have started. So, that's the case of Pickwell and Nichols and Procam CP Limited. Next, Carreras and United First Partnership Research. This is an EAT case dealing with what amounts to a provision, criterion or practice, and also it deals with the correct test for constructive dismissal. The background is that Mr. Carreras was a high-performing analyst working for the respondent. He'd been used to working long hours before a cycling accident caused him to suffer significant injuries. And the tribunal found these injuries included, and long-term effects included dizziness, fatigue, headaches, and difficulties in working in the evenings. And the respondent was aware of all this. Following an argument with one of the owners of the business, the claimant resigned and claimed disability discrimination and constructive unfair dismissal. The claim for disability discrimination was on the basis that there was a provision, criterion or practice that required the claimant to work late. Given his disability, he said, this was something that was more difficult for the claimant to do than someone who was not disabled, and furthermore, he claimed the respondent had not taken any steps to make reasonable adjustments. On this point, on this claim, the Employment Tribunal ruled against the claimant because of various findings of fact, which I'll go into in a second. In relation to the constructive dismissal claim, they also found against the claimant because they said his resignation was not because of the breach of contract by the employer. And both points were appealed to the AT by the claimant. The tribunal's findings of fact were that the claimant had been asked to work late, and this then mutated to an assumption that the claimant would be working 1 or 2 later nights during the week. So the claimant was being asked which nights he was working late rather than whether he was prepared to work late. Claimant's pleaded case was that there was a requirement that he work late, and that this requirement was a provision, criterion or practice. The Employment Tribunal said it was not a requirement that he work late, and so his claim failed. The Tribunal accepted that there was an expectation he would work late, but since the claimant had asserted it was a requirement that he work late, and this was not borne out by the facts, the Tribunal held that this meant that he lost. There was no requirement amounting to a provision, criterion or practice. The EAT felt the Tribunal had, and these are my terms, taken an overly technical approach to the pleadings. There was an expectation, on the Tribunal's own findings, that the claimant would work late 1 or 2 evenings a week. Having found that that was the expectation, that was sufficient in these circumstances, and his claim should be understood on a common sense basis, given that on at least one interpretation, one dictionary meaning, expectation and requirement can mean the same thing. Clearly here, there was an expectation that he would work late, as evidenced by the express request to him to work late, and then which night are you working late. So on this point, the claimant's appeal was upheld. The matter was sent back to the Tribunal to see whether and the extent to which he was placed at a disadvantage by the expectation he would work late, and whether there were any reasonable adjustments that should have been made. These points not having been dealt with because the Tribunal had found against him at an earlier stage in the process. So, I think the EAT decision is helpful. Here, there was no express rule he had to work late, and equally, he wasn't actually threatened in any way by the employer that if he chose not to work late, he would lose his job, for example. The issue was that there was an expectation he'd work late on a couple of occasions each week, and he tried to go along with that. And it's easy to see how a case could arise where the employer has stopped short of expressly requiring the disabled employee to do something, but equally it is totally clear that there is an expectation, potentially unspoken, that the disabled individual will work in a particular way or particular hours. The other point that came up when we were discussing the case this morning in the group was that even if there was an argument about whether or not there was a requirement that he work late, it would seem that there was clearly a practice that he would work late, and that, again, just looking at the number of people who were working late and how regularly they worked late, you might have thought would be another way of demonstrating that there was a provision, criterion or practice here to show that working late was a norm. In relation to the constructive unfair dismissal test, the claimant's appeal was also allowed, and indeed the EAT decided it would actually determine that there had been a constructive and unfair dismissal. It didn't refer it back to the Employment Tribunal. The EAT pointed out the test is whether one of the reasons for the claimant's resignation is the repudiatory conduct of the employer. It does not have to be the primary reason, it doesn't have to be the only reason. The claimant had, shortly afterwards, after he left employment, gone to live in the US with his wife, who was already out in the US. Obviously, there was a suggestion from the employer that the desire to go and live in the US was the motivating force in his resignation. However, he had resigned following a heated argument with one of the owners of the business, and the EAT was willing to accept that the claimant's behaviour subsequently might have been relevant to determining what his reason for departure was, but here there was no real doubt on the facts that the repudiatory behaviour by the owner of the business was a factor in the claimant's immediate resignation. It is relatively well established now that an employee can claim constructive unfair dismissal if the employer's wrongful actions are a reason, and they're only one reason amongst a number for the employee's resignation. This, in our experience, is a point that's often easily overlooked by employers. So that's the case of Carreras, United First Partnership Research. Third and final case, Gomez and Higher Level Care Limited. This is a case on the working time regulations. We haven't discussed a lot of working time cases in this podcast, but this case, although it relates to a very defined point, it is an important one, and had the case gone the other way, I think there could have been a number of working time cases coming through the system. Ms. Gomez worked in a business which provided accommodation and support for vulnerable young people. She's covered by the working time regulations, and as such she was entitled to a 20-minute unpaid rest break if she was working more than 6 hours in a day. Ms. Gomez won her claim in the Employment Tribunal and showed that she'd been denied her right to unpaid rest breaks. The question was, what compensation should be paid? Under the working time regulations themselves, the rules provide that the tribunal is to make a declaration and then award just and equitable compensation. However, this needs to take into account the employer's default and any loss which relates to the failure to apply the rest break. It was agreed that financially the claimant was entitled to £1,220, but there was one outstanding issue. The claimant asserted she had the right to be compensated for injury to feelings caused by the deprivation of her working time rights. In other words, she had the right to recover non-financial loss as well as financial loss. The working time regs themselves do not say that an individual is entitled to claim compensation for injury to feelings. Therefore, the claimant had to be creative in her arguments. Well, first she pointed out the regulations don't preclude an award for injury to feelings. The injury to feelings compensation is awarded not only in unlawful discrimination cases, but also where there's been a detriment on the grounds of trade union membership. The claimant also asserted it was necessary for there to be an effective remedy under EU law for breach of any EU-derived obligation. Failing to provide compensation for injury to feelings would be failing to provide an adequate remedy. The EAT disagreed. They decided that injury to feelings was not a permissible head of damages in the working time regulations claim of this nature. Injury to feelings cases are generally restricted to discrimination statutes, which focus on protecting a person's identity. This is obviously a different level from a failure to allow someone a 20-minute rest break. The EAT said that in that context, the working time claims and the failure to provide a 20-minute rest break was more like a breach of contract claim, where it's been well established, it's well known you don't get compensation for injury to feelings caused by a breach of contract. Also, the statutory basis for compensation for injury to feelings is explicit in the discrimination statutes. Now in the Equality Act, of course. The EAT said that in theory compensation for injury to health, as opposed to compensation for injury to feelings, could be covered by the working time regulations. However, the claimant had brought a case on the basis of injury to feelings rather than, for example, a breakdown in her health caused by overwork. So, the EAT's decision is clear. Breach of the working time regulations does not entitle a claimant to an award for injury to feelings. Not many cases on the working time regs are reported. I suspect that's often because the numbers involved are relatively low. In the circumstances, had this case gone the other way, and individuals could include a claim for pain and suffering as well as the financial loss, I suspect that we would have had rather more cases in the tribunals for breach of the regulations. Although there was some suggestion during the EAT hearing that the claimant, if she lost, might seek a referral to Europe to ask for a ruling from the ECJ that she was entitled to damages for pain and suffering, in the end she didn't follow up on that. In the circumstances, it looks as if the sanction for employers who failed to provide unpaid rest breaks or other working time rights is primarily going to be to assess quantifiable financial loss caused to the claimant. So that's the case of Gomez and Higher Level Care Limited. So I think it only remains to say thank you very much indeed for listening. Would do a plug, please, for the guest podcast that I did with Liz Stern on global mobility matters last week. We've had a number of quite nice comments in on that, so thank you if you're one of those who emailed in. But Liz is good company, as I hope comes across in the podcast, and has a number of interesting points to make. And thank you everyone for listening, as I say. And yes, it's amazing to think that by the time we do the next podcast, we'll know whether we've voted for Brexit or not. And let's face it, there's only one right answer to that question. So until next time, please do vote and stay safe.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.